The Court of Appeals orders the city prosecutor of Taguig City to file rape and acts of lasciviousness charges against TV host and actor Vong Navarro. In a decision to dismiss the DOJ junk model Denise Cornejo's 2014 complaint accusing Navarro of attempted rape, the CA reiterates the
But the Taguig court grants the bail petition of host comedian Vong Navarro, allowing him to pay 1 million pesos for his temporary liberty. The ruling also mentions how Cornejo claimed she was drugged, but later testified she wasn't sure.
To discipline, the release to admonish and to reprimand this group that treats itself.
Court or RTC Branch 256 denied the petition for bail by former Senator Laila de Lima. The court said that based on the testimonies previously presented,
For the third time, the Sandigan Bayan denies the request of former President Gloria Arroyo to be released on bail because of health issues. The Sandigan Bayan says Arroyo is not, quote, very sick as her lawyers would like the court to believe.
This is a man's world. This is a man's world.
Bail. As defined in Rule 114, Section 1 of the Rules of Court, it is a security given for the release of a person under the custody of law furnished by him or a bondsman to secure his appearance before any court. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance.
When is the right to bail may be invoked? In the case of People v. Fitzgerald, the right to bail emanates from the right to be presumed innocent. It is accorded to a person in the custody of the law who may, by reason of the presumption of innocence he enjoys, be allowed provisional liberty upon filing of a security to guarantee his appearance before any court as required under specified conditions.
Under Rule 114 of the Rules of Court, that any person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality where he is held.
Bail is a matter of right. All persons in custody shall be admitted to bail as a matter of right, with sufficient sureties or release on recognized as prescribed by law or this rule. First, before or after conviction by the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court. Second, before conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, be admitted to bail as a matter of rights, with sufficient sureties, or be released on recognizance as prescribed by law or this rule.
Bail when discretionary. Upon the conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it has not transmitted the original record to the appellate court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved by the appellate court. Should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail, subject to the consent of the bondsman.
If the penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail, or his bail shall be cancelled upon showing by the prosecution with notice to the accused of the following or other similar circumstance. First, that he is a recidivist, a quasi-recidivist, or a habitual delinquent, or the crime he committed is aggravated by the circumstance of reiteration. Second, that he escaped from a legal confinement, evaded sentence, or violated the conditions of his bail without valid justification. Third, that he committed an offense while under parole, probation, or conditional pardon. Fourth, that the circumstances of his case shows probability of flight if released in bail. Fifth, that there is undue risk of committing another offense during the pendency of an appeal. The appellate court may motu proprio or upon motion by any party review the resolution submitted by the regional trial court after notice to the adverse party in either case.
The right to bail is an essential component of due process and is protected under the 1987 Constitution of the Philippines. Section 13, Article 3 of the Constitution states that all persons except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required.
This constitutional provision establishes the general principle that individuals are entitled to bail unless they are charged with offenses punishable by reclusion perpetua and the evidence of guilt against them is strong. In contemplating the application of right to bail, here are the key points regarding the right to bail under the 1987 Constitution.
First is the presumption of bail. The Constitution establishes a presumption in favor of bail. It means that unless the offense is charged is punishable by reclusion perpetua and the evidence of guilt is strong, individuals are entitled to be released on bail. This presumption places the burden on the prosecution to present evidence to justify the denial of bail.
Second, sufficient sureties and recognizance. Bail can be granted through two means: by posting a bond with sufficient sureties or through recognizance. The court may impose reasonable conditions when granting bail, such as requiring sureties or placing restrictions on individuals' movement.
Third, non-impairment of right. The right to bail is guaranteed even during times when the privilege of the writ of habeas corpus is suspended. This ensures that individuals are not deprived of the right to provisional release even in exceptional circumstances.
Lastly, protection against excessive bail. The Constitution explicitly prohibits the requirement of excessive bail. The determination of bail should be reasonable and not punitive in nature. Excessive bail refers to an amount unreasonably high, effectively preventing an accused person from securing their release.
It is important to note that while the Constitution establishes the right to bail, it also recognizes exceptions for certain offenses or circumstances where bail may be denied. These exceptions are designed to address concerns of flight risk, danger to public safety, or obstruction of justice.
The exceptions of right to bail are: first, when charged with an offense punishable by reclusion perpetua and evidence of guilt is strong. With an offense punishable by reclusion perpetua, it is the duty of the judge to determine if evidence of guilt is strong for purposes of deciding whether bail may be granted or not. If an accused who is charged with a crime punishable by reclusion perpetua is convicted by the trial court and sentenced to suffer such penalty, bail is neither a matter of right on the part of the accused nor a matter of discretion on the part of the court. An application for bail must be denied.
Second, the right to bail has been recognized and is not available to the military as an exception to the Bill of Rights. The Supreme Court observed that the right to speedy trial is given more emphasis in the military, where the right to bail does not exist. The denial of the right to bail to the military does not violate the Equal Protection Clause because there is substantial distinction between military and civilians.